your friendly HR Industrial Relations consultant for IR Law. Aside from me, we also have Mr. Manjeev, who is attending this webinar with us today, who is an associate consultant with us. So without further ado, let me first give you a brief background information on Mr. Amardeep Singh. Mr. Amardeep Singh handles both litigation and advisory matters of all aspects of employment and industrial relations law. So you could say he's an expert in industrial relations and employment law. He also advises corporate clients on immigration laws and management of their foreign workers and expats, as well as employment-related tax laws in Malaysia. Mr. Amardeep Singh is a graduate of the University of West of England, Bristol, and a member of the Honourable Society of Lincoln's Inn. Amardeep was called to the Bar of England and Wales in 2012. He was admitted as an advocate and solicitor of the High Court of Malaya in 2013. So, Mr. Amardeep Singh, I'd like to welcome you for today's webinar. Thank you very much. Without further ado, Mr. Amardeep Singh on managing performance for remote employees. Thank you.
Thanks, Vishnu. Sorry, just give me a second while I try to sort out my slides. Okay, can you see my slides, Vishnu?
Yes, full screen.
Yes.
Okay, full screen.
Yes.
All right. Thank you very much for the introduction, Vishnu. I noted you're a friendly consultant, and I can agree. He's a very friendly consultant indeed. Hi, everyone. Hope everyone is keeping well. I would firstly like to thank IR Law, as Vishnu has said. There's a few times I've collaborated with IR Law, specifically even during their IR Law conference 2 months ago, and I had a great time. Specifically, I would like to thank Umi for arranging and also coordinating this webinar. I would also like to thank all of you all for taking your time off today from your busy schedule. I don't know whether I can agree with Vishnu to say you're the most you all are the most fortunate to hear me speak, but I'm truly grateful that you all are able to join me for this webinar today. I see we also have a very good crowd today. I hope it's for knowledge learning. I hope you're not here because you're facing issues with the performances of your subordinates, or are finding ways to unceremoniously dismiss any of your employees on poor performance. Before anything else, let me go into this topic first of all. Poor performance or managing performance of your remote employees. The focus that we'll be having today, I think, is it's very relevant to current work environment. Even though we do see some businesses opening up, as we saw PwC announcing that their US-based consultancy firm will be going full work from home for life, full time, right? And I think we may also see certain companies do the same. If not for good, it may be for an extended period of 6 months to a year, right? Enough time for you all to take some steps to deal with performance issues that you all have, especially now where most employees are working remotely, and the interaction between a superior and his subordinates is reduced to this Microsoft Teams, right? To Zoom. Today we will take you through an understanding of something very important that you all as superiors must understand is what is poor performance, first of all. What is performance issues? Then what you should consider when handling someone who's not performing well. I'm sure a lot of y'all that are here are not here to hear how do I handle an employee that's doing well, right? We all know how do you do that. But it's always about how do you handle an employee who is not doing well. So that's what we're going to take you through. Then we'll also try to go through some common pitfalls. Because working from home is such a new thing in Malaysia. It was not very common before this. You saw it in tech companies, right? You saw it in startup companies, but you never saw it in your MNCs, right? You never saw it in law firms. I couldn't imagine how a law firm could operate working from home without having to go through the bundles. Things like OneDrive, Dropbox were things that we never heard of. We never used. We just thought it was too difficult. But today things are very different. And even we are working from home and we are also facing the same difficulties. How do we motivate our employees? And for our employees who are, not performing well, how do we handle it, right? We can't obviously just dismiss. First things first is, if any of you all here who are not from the HR background, I'm sure IR law would have well advised you all. In Malaysia, unlike Singapore, you cannot hire and fire at will, right? So you will always see an employment contract which says this employment contract can be terminated by the employee or the employer by giving 2 months notice. That is enforceable in Singapore, right? But you cross the border and you come here to Malaysia, you can only dismiss an employee if you have just cause and excuse. And if you do not have just cause and excuse, the employee can take it to the industrial court and argue his case there. And what is just cause and excuse? First one, obviously, poor performance, misconduct, and then the third one, retrenchment. Today we'll be discussing poor performance. So what is poor performance? There's always a bit of a confusion between performance issues and conduct issues. A performance issue is, for example, deficiencies resulting from, first one, inefficiency. Inefficiency because someone cannot do it to achieve the maximum productivity that he should have, right? Or incompetence or inaptitude, which is you're unable to satisfactorily carry out the work. That means the person carries out the work, but it's not to the satisfaction of his superior. Or maybe he just doesn't have the skills to carry out that work. But you also have a quasi-conduct, poor performance issue. For example, neglect. You tell an employee to do something and he forgets, right? Very busy, Netflix is on. He has to go in to watch the Netflix episode. So he forgets. So neglect falls under misconduct. We will not be touching that. Or you tell him to do something and he tells you, this is not in my job scope, I'm not going to do that. Insubordination. We will also not be touching that. That's misconduct again. We will be touching when an employee is supposed to do something, he does that, but he does not do it well enough, right? So unlike misconduct, as we can see earlier, an issue of poor performance does not necessarily mean any wrongdoings on the employee, right? It just means the employee could be lacking the necessary skills. He could be lacking the necessary training. And it's right law that if an employee doesn't have the necessary skills or is lacking the necessary skills, the employer is free to dismiss the employee. However, before you do so, it doesn't mean if you tell an employee you need to sell 15 cars in a month and the employee sells 8 cars in the month, right? It does not mean you can dismiss the employee straight away, right? Reason why is there is a test that's been developed by courts. You need to apply this test and see whether have you satisfactorily dealt with each one of these questions that the court has put forward. So what are the questions? So this is where as superiors, it's very important that before you can even deal with the poor performance issue, you need to understand what you need to deal with. Because when this matter goes to court, I've had cases where, put simply, the employee couldn't hit his targets. And not that he was missing it by 10%, 15%, he was missing it by 50%, right? He was missing it by a good sum. And then the court said, what was the issue? Why was he missing these targets? And realized that he may have lacked certain training. And then looked at it and said, what did the employer do to give him a fair chance? Did you give him this? Did you give him this training? No, the employer didn't do so. So even though the employee was clearly incompetent, right, or inefficient at the very least, the court still held that the dismissal was without just cause and excuse. Still awarded a handsome sum against the company. Right. So the question, the 3 things that you need to satisfy the court is this, which also then applies for remote workers. First one is, have you warned your workers or your subordinate about his poor performance? Number 1. Number 2 is, have you accorded your subordinate a fair chance to improve, right? A sufficient opportunity to improve. And the third one is, notwithstanding the first 2, the warning and sufficient opportunity, this guy still cannot improve, right? So if let's use the car example again, he doesn't hit his targets by 50%. You now give him a chance. You send him for training. He still doesn't hit his targets. So you have done everything you can. You have already warned the guy, you have given him sufficient opportunity. He still doesn't improve. That's when you can take the third step is, notwithstanding that, his target only moved from 50% to 53%, right? He's still well off. So you have no choice but to dismiss this employee. Now, these same principles apply, whether it's a remote working environment or whether it's a physical working environment, these same principles still apply. In fact, it could get even trickier because previously an employer, so a superior and his subordinate will meet on a day-to-day basis. Now you don't. So now you need to take steps to ensure that every step that the court has said, which is relevant for a physical work environment, must be now transferred into your virtual work environment, your work from home. So some examples I can just give you very quickly is, why do you have this test, right? Let's use an example, sufficient opportunity to improve. No two cases are the same. So if you have got an employee who's careless, right? Let's just use the simplest example, typos, right? And his issue is he's putting up reports with a lot of typos, a lot of data that's been given to you is erroneous. 1 month, do you think 1 month is fair amount for him to improve? Yeah, right? If you tell someone to be a bit more careful, tell him that maybe instead of looking at the data on the computer, maybe you should print it out, you should highlight, right? And I give you 1 month to stop all these careless mistakes that you're making and this data entry that you're doing, right? Sounds like a fair time, right? 1 month. But now let's say we change that, right? It's not data entry or typos. Let's say it's language. Maybe the person doesn't speak well. He speaks good, right? He's got some grammatical issues, right? In his reports and stuff like that. Or maybe it's sales targets, or he doesn't lack the necessary knowledge. Do you think 1 month is fair? No, no court will find 1 month is fair. You cannot tell someone to improve his language from good to well in 1 month, or improve sales targets from 50% to 90% in 1 month, or improve his knowledge in a specific area in 1 month. No court will find that to be relevant. So this is why this test is very important. So let's then look at what's the purpose. The first purpose is the purpose of the first question, warning. Why do you warn your employees? The first one is to put an employee on notice of the employee's dissatisfaction. So in other words, let your just give me a second. Let your employee know that you're not happy about his performance, right? That also then provides an opportunity to the employee to be aware of his poor performance, right? And it also notifies him of the risk. What will happen in the event he does not improve his performance? You should also, in your warning to your employee, specify the time period during which you expect improvement. So for example, you warned him on the 1st of January that looking at your performance appraisal last year, you did not fare well in these following areas, these 7 areas. I expect you to take steps to improve. The timeline within which you should take is 6 months or 5 months or 3 months. So how should you issue a warning, right? And this is where it's very important, especially in work from home environment, when you do not see your employee. The first thing I guarantee you in every poor performance case that I've dealt with is my superior never spoke to me, right? My superior always told me I was doing very well. They will always refer to past bonuses. Yeah, I got a bonus of 6 months or 2 months in 2013. In 2014, I got a bonus of 1 month. I even got an increment in 2013, 2014. In 2015, suddenly my superior says I'm a poor performer, right? And he puts me on PIP. And it's something I've never heard of. And then when we ask the superior, can you pull out some documents to show us that you have corrected the person? The superior looks at us with a blank face and says, no lah, I always did it face to face, right? I always did it through verbal meetings, during meetings, and I never wrote anything down, right? So the best practice is always speak to your employee, speak to your subordinate, issue a warning. It must be in written form. This with the whole work and from home environment, you're likely to have your conversation with your employee from Teams, right? It's likely to be even through a Zoom call. You can even consider from Teams, I know you have that feature, you can transcribe it. if you're going to have that meeting with your employee to inform him that he's performing poorly, turn on the transcribe mode, send it to the employee and say, hey, this is a record from our meeting. I want both of us to keep this copy. So we are aware of where we need to improve and what has been discussed, right? Or if you feel that is too confrontational, I understand some employees will not like it if the employer is recording or an employer is transcribing what they're saying. They could turn around and say that, the employer seems to have been taking steps instead of helping me improve, maybe taking steps to just ensure that when the case goes to court, that they win. So in other words, you have already made the decision, you're going to dismiss them. So what you could then do is have a call with the employee, tell the employee where he's not performing well, what steps he should take, then send an email that, hey, this is the conversation we just had. I'm just recapping and all the points that you all had spoken about. End it with, very simple, always end it with any email, right? Hi, if you're unsure or like to discuss anything, please feel free to arrange a meeting or to contact me, right? Always end it with that. Then the onus falls on the employee if he doesn't respond to your email, or if he doesn't send you an email telling you that I would like to have a discussion, you can go back to court and always tell court that. That's the record of what was discussed with him. If he had an issue with what was discussed, surely he would have come back. So this, what it does, right? It limits the room for an employee to wriggle in court, right? Because very often the employee will state lack of guidance, no counseling, I had no meetings with my superior. And this is only going to increase in a remote setting, because besides that one-to-one call that you have with your employee, which you probably may have once a day, right? Once every 2 days, you're not going to be having such calls. Also, what happens is when you do not capture your calls or guidance given in email, what would happen very often is poor memory. When you go to court, which will be 2-3 years later, the superior will not remember. He will only be able to tell you, yeah, I remember having a call with him. And this was the actual case, right? These are actual examples I'm giving you. I remember having a call with her. We had lunch, and after the lunch, during the lunch, I'm very sure I told her about this performance issue. And I'm like, oh, okay, who was present at the lunch? She's like, just me, her, and this other person that she used to work with all the time, was sort of her buddy, right, who was assisting her. I said, okay. And then I said, so was this a work lunch? And he said, yeah, it was. Then I'm like, oh, perfect. You would have claimed it. And he's like, oh, yeah, I did. And he went and checked. And the funny thing was that lunch occurred after she was dismissed, right? So it was, again, poor recollection. He was actually thinking of another incident. And then when I asked him to confirm, he said, oh my God, you know what? The entire story I narrated to you was actually with a different employee, right? And that was nothing to do with our case. So again, that's why document. When should you issue this warning? Very important, promptly. Do not delay. The moment you recognize some sort of performance issue, have a call with your employee. Tell them that, hey, I'm starting to notice that, work is starting to be very slow from your side. There are a lot of careless mistakes that's coming from you. I hope you can take some steps, or, is there something that's bothering you? You could start off being less confrontational, right? Asking them what is concerning you. Is there something? For all you know, the employees, he may be having a newborn. Maybe the wife just went for vaccination. She's not well for 1 week. And then 1 week has really bothered or interrupted his work. For all you know, there may actually be an actual reason, right? Where there is none, then probably it's more of a wake-up call, so that the employee is aware that his employer is aware, okay? Delay can always, in any case, whether it's misconduct or poor performance, amount to condonation. The court could just say that, yeah, this employee he got a sales target of 75 last year in 2013. 2014, he got 80%. The year after that, he got 75. It's always been normal. The employer never took any steps. Quite obvious, it was never an issue. You do not have to wait, which is the common misconception, is you have to wait until the annual appraisal is done. You don't. Technically, what your annual appraisal is supposed to be a sum up of whatever took place during the year. So everything that you see in an annual appraisal should have been communicated to the employee or indicated to the employee throughout the year. I know some employees that, especially now in a work from home environment where you do not have that day-to-day interaction, a lot of employees will probably come up when you issue them their annual appraisal and come up and say, I never saw this. I never knew this, right? You suddenly at the end of the year in December tell me that I'm not performing well. I cannot collaborate with my team. But throughout the year, nothing was said to me. So the next question then is, did I skip that? Okay, the next question then is sufficient opportunity. So in this, sorry, is there?
Baik, beli banyak sikit baik roti.
Sorry, not too sure where the sound is coming from. Okay, yeah, so sufficient opportunity to improve. So what sufficient opportunity to improve means is this: you must give them a reasonable opportunity to improve, which means number one, sufficient time, and number two, reasonable targets, which is something that we discussed earlier. So I've got some examples here. The first one, in this case, the employee worked with the company for 16 years, right? Unblemished record, no issue with this employee. Throughout that 16 years, he received various promotions, received various increments. Then he was transferred to a new department, right? He was transferred to a new department. 3 months into that transfer, he was told that he failed to achieve targets in his new role and he was dismissed. Even hearing that, you know it's unfair. So what the court held was this. The court held that he should have been given a longer time to achieve his targets, especially after he was transferred. It's different possibly if this employee had been working for 1 year, right? Then he was transferred. But here you have an employee that's been working for 16 years. Quite obvious, there has been a change to a different department, a change of environment. The second one is, and you can apply this again to your remote work setting. If you've got an employee that's always been working from office, right? Having that physical interaction, working with his colleagues, collaborating with his colleagues, and suddenly he has to work from home. Courts may be slow. They may say, you know what, this is a global pandemic. It affected a lot of people. It affected a lot of people differently. Some were hit simply having to work from home, right? It's not easy staying home for 3 months. Now, having gone through all that, the company should have been slightly slower, right? You should not have just jumped the gun and dismissed the employee. Now, in the second case, the same time frame, that's why I used these two cases, same time frame, an employee was put on PIP, 3 months. He was expected to achieve 70% of his target, only 70% during the period of the PIP, which again was revised down subsequently. He failed to do so, right? He was warned and put on PIP again for another 2 months. The court held, yeah, the company has given him ample time. Firstly, 3 months, reduced his targets to 70% instead of 100%, which was subsequently revised again. He was warned, put on a subsequent PIP, and then only they took the step to dismiss him. The other one is, another example is, the court took into account guidance. How much of guidance and feedback was given to these employees? So now let's look at the possible issues faced by employees, remote working employees, right? First one being, so what I'm going to do here is possible impact to these employees and possible cases that we can relate to. So first one is the impact on productivity itself, which is what I was speaking about earlier, is not easy staying home for 3 months. So the conditions, environment while working remotely are not conducive. So in this case, it involved announcer for THR Gagar, sorry. And for a decade, he was working with them for 10 years, and he was dismissed on the grounds of poor performance. Around 2016, the radio management company had undergone changes. The working environment and the customer expectations during that time frame was changed, and the need to multitask and learn new skills was required. This was when we were moving away from our traditional radios to more our virtual podcasts and virtual radios. The court held that good industrial relations requires an employer to provide enough time and training for the employee, and the claimant to adequately adapt and improvise into the ever-changing work environment. So in other words, what the court said was the company didn't do enough. The company should have seen that there was a change in the work environment, which now required him to multitask, learn new skills. He should have been provided sufficient time. So this is very relevant, especially when you have cases where companies go through M&As, go through mergers, or there's an acquisition of a new business. And subsequently, obviously, there may be a decision on which employees to retain. And very common, employees may be retained from company A or company B. And they go on the grounds of poor performance, simply because company B employee cannot work under company A or company's A of working style. And this is where courts have held that you need to give them enough time to adapt. So if the company makes a change, or in this case, globally there's a change, you must give them enough time. Second one is lack of guidance. So in this case, what happened was the employee was dismissed shortly after 4 months. So this will be very relevant for your new employees. No training was given to this employee. She was assigned 4 different job scopes and departments in that 4 months. She was then dismissed on the grounds of poor performance. So the court took note that there was no training provided to her in each one of these different departments that she worked in. There was also no sufficient time for her to improve or to rectify her shortcomings, because when she was trying to rectify her shortcomings in department A, she was sent to department B. Subsequently, when she was doing some work for department B, she was told to do work for department A. So in that 4 months, she did work for 4 different departments. So the court again took account that this is a new employee. You must obviously assist or hold their hands a bit more. You must be a bit more hands-on with these employees, especially if they are new employees and they are junior employees. It's different. You will not expect this from your CFO. You will not expect this from a COO. So other common issues that you should consider is domestic issues, right? There was a report in, I think, China that in the first MCO itself saw an increase of domestic abuse by almost 30%, right? So it's a real problem that people are facing. The other one is more relevant, lack of supervision and face time. Some employees work better as a team player, right? Some employees feel a bit disengaged when they're having to work alone. They feel, in fact, in my office itself, I spoke to some of my colleagues and I asked them, would you all prefer a work from home environment or would you all prefer working from office? And they told me that they were struggling working from home only because life has become a loop, right? They wake up, they go to office, they wake up, they turn on their computer or they have their coffee, turn on their computer, do their work until evening, they close their computer, they go back. They start again the next day. And I was considering telling them that, you can all work from home as much as you want, whenever you want. In fact, don't even come in. Let's reduce the risk. And they told me, no, we want to come in. We want to come in certain days. We want to talk to each other. We want to go down, maybe even we can't eat, just tapao food together, have that conversations with our colleagues. The other one is, of course, too much of work from home, which is when things get, when the lines between working from home and leisure times are blurred. You may see employee motivation levels drop, right? So this is where you straight away, as an employer or superior, you should recognize it as a red flag and possibly take steps. Try to identify what's the issue. The other one is resources, right? And I think this is an issue that affects even the legal industry. We don't have technological issues, but the issues that we have is resources. A very important, very big part of the work that we do is research. And we are unable to research only because we have no access to our library, right? We are unable to carry out certain research that we want to. So I've some red flags that we have already spoken about is when do you see red flags? When do you think it's time for you to approach your employee? When he consistently fails to produce the results, when he's starting to miss deadlines, fails to hit targets, makes more mistakes than others, quality of work has dropped, sloppy, typos, things are being done at the very last minute, things are being done late, important projects or data entry is wrong, increased hand-holding, and he's starting to rely on his colleagues. So in other words, he's unable to do it. He's asking, hey, can you help me out? Hey, can you also help me out? That's when those are the red flags where when you see it as an employer, you can jump in. You should jump in and start speaking to your employees. So now I've gone through the performance issues, what you should see, what you could see. Now I'll go through on steps you can take as an employer or steps that you should take, right? If this were to go to court, if you have taken these steps, very likely the court will be with you, especially it's done well. Performance improvement plan. Everyone's heard this, I'm sure. Right? So what's a performance improvement plan? It's a set of guidelines given by an employer to an employee who consistently performs below standards. So in other words, you're telling the employee that you're not performing well. I need you to buck up. These are the areas where you need to buck up, and that's where you need to buck up. The purpose it serves is this. Firstly, you've flagged the unsatisfactory performance. It comes after the warning, by the way. And the second one is the details or method or process required for improvement, right? Or even the training, right? So if you have an issue, you tell them your sales target was 50%. Your sales achievement was 50%. Your sales target obviously is supposed to be 100%. You have not achieved it by more than 50%. Now, what steps he needs to take? Obviously, in that case, very simple. He needs to hit 60% within 6 weeks. He needs to hit 70% within 3 months. He needs to hit, you can go on, right? Then you ask the employee, what steps can you take to help him? Maybe he may tell you, boss, I only just moved to Sitiawan, this place is dominated with people speaking Hakka. I only speak Mandarin. So then my Hakka is very weak. Then okay, fine. Maybe it's a language thing. Maybe he needs some training, right? Or maybe he turns around and tell you, boss, I'm not too sure how to sell cars, right? The job that I used to do earlier was selling something else. Then you may need to send him for training on how to improve his sales knowledge, right? So you need also then set very clear timelines. You cannot tell him improve your sales targets when you like it, right? You need to be very clear on the timelines. Because the PIP, when it goes to court, it will be the foundation. The court will look at it and ask, did you have a PIP for this employee? And it's the very basic. If you do not have it, very hard to prove you had good reason to dismiss an employee. Your ultimate goal as a superior is use the PIP to coach and give assistance to your employee. Never use the PIP as a basis for an unceremonious exit, because it will be picked up by court. The court will see and say, yeah, you don't look very genuine. You really wanted to help the employee. You would have more than one meeting with him a month, right? And that's an actual case. So this is an example of how a PIP should look like, right? I've taken it online from one of the clients. So description of what the underperformance is, aim, when you plan to start, when you plan to end. You must ensure, in a recent case, the court held against me, right? In this case, the court held against me, but there were so many issues for us to iron out. And one of the issues that we had was here. My client had the PIP start date. Let's say it's supposed to start in January, right? And it's supposed to run until June. There was evidence, documentary evidence showing that this document, which is the PIP report, not a report, the PIP action plan, was not even finalized until February or March, right? So the court looked at it and said that, how is it that you all are working on a PIP? The start date has already commenced, but I see emails here showing that you all are still discussing what he should achieve and what he should not achieve, right? So what constitutes an insufficient opportunity to improve? What you should stay away as superiors, what you should stay away from. This will obviously apply even in a remote setting. First one, setting unreasonable goals, expecting drastic improvement over a short period of time. So in this case, the employee was accorded 3 months to improve her sales targets. In that 3 months, the employer very responsibly had 3 counseling sessions with the employee. So 1 month once, in order to assist her to achieve her sales target. The court held no reasonable time was given to the employee, first of all, and no reasonable opportunity was given because three times in 3 months is insufficient. The next one is vague descriptions. on what are the PIP targets and the deliverables which the employee must keep or must do within within the time frame. This includes things like PIP. You need to improve, for example, description of the underperformance, right? Areas of improvement or the action plan. The list of variables, the court said, appeared to also be new areas, things that was not directly related to the employee's responsibility, nor was it anything to do with her work, right? Nothing to do with the job description. So here again, for remote employees, you need to set clear PIP targets. It will be even more important than a face-to-face interaction because you do not have face-to-face interaction. So it's even more important than your physical work environment. Next is little to no guidance. And here, you rest assured, when it comes to a remote employee, the first thing they're going to go and say that, yeah, I didn't have the chance to meet my superior. I met him once every 10 days. He was too busy for us. Okay. So what do you do for remote employees? Set frequent meetings. Where required, send or propose to them for employees to be sent for training. Inform the employee where source of information can be obtained and always capture this through emails. I will not go through the case, but in this case, very simply he was not provided any assistance, no training or counseling. So the court held that this was the very basic when it comes to trying to make an employee improve. For example, when it comes to things like more quantitative, like sales. Insufficient progress meeting. So this is linked to earlier. Having 3 meetings in 3 months, not sufficient. Here, the court held that there was no reason why there seems to be, the employee was put on PIP. Subsequently, there was no meetings, right? He was just dumped on PIP. This is what you need to do during the PIP. See you later, right? The court said, no, there is no reason given from the employer why there were no meetings. Why couldn't you meet him every week, right? Why couldn't you meet him every 2 weeks and ask him, hey, what's going on? How's everything? Is there something we can do? So the court said, to me, it doesn't look like it was genuine. It looks like a showpiece for a collateral purpose. In other words, the court stopped short of saying, you only did this because you wanted to dismiss the employee. So you put him on a PIP, right? Next is delays. Delays in setting your KPI or targets. Here, this is a recent case. What happened was the employee's time frame to achieve his targets was January to December, right? Here, the court saw that there was evidence until June, right? May, June, the employee was still discussing with his superior on what his target should be for the year, right? In other words, you're only giving the employee now a reduced time. You're only giving him 6 months to achieve what he's supposed to achieve. And this ties back earlier to what I said earlier about PIP as well. If you're having a PIP, ensure the document, everything is completed before the start date. So if the start date is 1st of January, you should be having discussion with the employee in December on what the PIP should be and finalize it. Unclear definition of the employee's duties, right? So this is less of a PIP, more of the employee's role itself. So in this case, the employee was made to carry out work which was beyond his job description and KPIs during the PIP. The court looked at it and said, no, this is not fair. The company tried to argue that his job description and his KPIs are very general in nature. In the PIP, we are a bit more granular. So, we list down A, B, C, D, E. The court took none of it, didn't entertain it. The court said, no, I'm not having any of it. Quite clear that the PIP included items that were never part of his job description or KPI. So be very careful about that as well. How you phrase your PIP goals. Inconsistent assessment. This was something that I discussed earlier. Something I spoke about earlier, that you wait until the very end, until the year-end appraisal to tell an employee that he's not performing well. It won't work. You need to be doing it on a regular basis. If the employee is not doing well, he should be told. You do not need to wait until the performance appraisal to put him on a PIP. Obviously, it's very convenient if that's the case. That can be the reason for putting him on a PIP. But if your company policy doesn't state that, you can actually put him on a PIP anytime. Repeated transfers. So in this case, the employee was repeatedly transferred on a yearly basis. So this is something also you want to avoid. Changing job scopes, changing superiors, changing departments. things that you want to avoid when an employee is already not performing well. And the last one is the superior itself. In a recent case involving Petronas, the court looked at it, inquired about the superior, and then said the superior lacked the necessary experience. Quite clearly, he doesn't know how to coach, encourage, or praise the claimant. Obviously, the court went on further to say that the superior had ulterior motives, wanting to get the employee out, by placing her also in a new department, placing her in a new area, uncharted waters, and then not trying to teach her in these uncharted waters, and instead trying to just give her targets which he knew she would not achieve, and therefore just get her sacked. Yeah, running out of time. So just run through the last few slides. Is so what you should do when you're handling a PI, when you're carrying out a PIP, ensure your job requirements, standards, performance measures are clearly communicated from the onset. Obtain acknowledgement from the employee, regardless of whatever it is, whether it's a performance, misconduct, anything, everything should always be in writing. Never communicate verbally, and do not send an email. Identify the areas that need correction, highlight in detail the employee's shortcomings in the PIP forms, use specific examples. I've seen PIP forms that now we are having to argue in court, where the company just says things like lack of collaboration, unable to collaborate with teammates, and no examples are given. And that superior, unfortunately, has left. He has left the company, and we are having to now dig through the emails to show what did the superior mean by lack of collaboration, right? We are unable to find. And very likely, it may actually just be thrown out. Provide guidance on how to improve at set intervals. This may be training. You can also assign buddy, right? A buddy system. Certain industries, it might be relevant. For example, if it's in the legal industry, this would be very relevant. Where do you find resources, right? How we carry out research, maybe various different ways we can do so. Provide sufficient time to improve. Each case should be taken differently. Some people can be put on PIP 3 months, some 6 months. Obviously, do not go against your policy. Everything that has been spoken to the employee during the PIP should be on the PIP form itself, and review it against an objective criteria. Very simple. I've got I'm sure you all know about this. SMART. That's how you do it. Specific goals, measurable goals, achievable goals, realistic goals, and timely goals. This is how you should go about carrying out your PIP. Okay, let me just run through some litigation tips before I end this. Okay. Common issues that we face in court. Two things that I just want to bring up. The first one is inaccurate reviews given with the intention to motivate employees. Mask performance issues. I've had cases where employee was receiving high performance rating, year 1, year 2, above average, year 3 above average, year 4 onwards, poor performer. When we asked, they said, the employer told us, oh yeah, previously we really didn't care about this performance appraisal. You know, it was just a thing that we had to do. So we just did it. We just want to make everyone happy, right? Never do that. You're not only setting your company to fail, you're also setting subsequently your next, whoever, if you were to leave as a superior, all that problems that they have to deal with, right? Or you do it simply because you don't want to have a situation where your subordinates are unhappy, or you have to deal with a negative subordinate, or have to deal with someone that's not being too happy while working from home. The other one is don't document, right? Another litigation tip is not documenting. So in other words, you tell an employee he has not done well. Maybe it's about some slides, right? Maybe it's about a meeting, right? And you do not document it. You should always do it. Just drop an email. Hey, as discussed, this was the issues. I hope you take the steps like what I've told you. Okay, with that, running out of time, so I'll take some questions. For the slides, if you all would like the slides, you can email me. My email address is there, ast@lh-ag.com. And with that, thank you very much, everyone. I will now take some questions. Hi, Umi, do you want to?
Okay, that's our first question. First question, do we need to specifically state in the PIP letter when it will end if the guideline already specifically stated how long is the tenure of the PIP?
Okay. So what you're telling me is your PIP policy already states how long the PIP will last. That's right. Right. So my advice to you is it doesn't take effort. It doesn't take any effort. It doesn't take any effort for you to state on your PIP form that your PIP starts on this date, your next meeting will be on this date, and your date your PIP ends is on this date. Because depending what your policy says, if your policy says all PIPs will be for a period of 6 months. Now the few issues they're going to have here will be for a period of 6 months, fine, that's no issue there. Or will be at least for a period of 6 months. That means it's more than 6 months, could be 9 months, could be 1 year. Or your employee, the other issue, you could turn around and say that, was this PIP guidelines ever given to me? I'm not aware of it. I've never seen it, right? So why put yourself in that position when you can just very easily just write there, this PIP will be running from this date to this date with meetings on this date to this date. But it's not fatal. It's not fatal.
Okay, next question. After the PIP, which is 6 months, staff has improved on work performance. Unfortunately, a year later, the work performance started to decline. In this situation, can the company dismiss the staff on this ground, or should the company repeat the PIP process again?
Sorry, I can't seem to find this question. I'm looking at the chat.
From Miss Jacinta Francis. Miss Jacinta, you can unmute yourself if you want to clarify this question.
No, because I can't see the question on I'm assuming she posted it on the chat.
Yeah. Oh,
Yeah.
yeah, this is directly to me. Sorry, let me read it.
Right, that's right.
Okay,
Yeah,
hi.
do you mind just sending it? Maybe Umi, you can just send it to everyone while I take the other question, then I'll take this question.
Okay. It's
Okay.
supposed to be to everyone.
Right. So Hui Mian Yap, I see your question. Do we need to pay termination benefits to the staff if it's terminated, if the staff is dismissed because of PIP? Termination benefits kick in only if, short answer no. Short answer no, you do not need to pay termination benefits if the staff is dismissed because of a PIP. But usually what employers do is they make payment of notice in lieu of payment in lieu of notice, or they let them serve their notice period, because this is not a conduct issue, right? This is sort of an employee who just cannot carry out that work. He's tried his best and he's unable to carry out. So what I always advise my clients is, while your contract unless your contract very clearly states you can dismiss someone on the grounds of poor performance without providing any notice, do give them their notice period, right? At the very least, you can very well then go to court and say that, hey, this is an employee that couldn't serve us, he couldn't perform well enough, but we didn't treat him like he's a criminal, right? We didn't treat him like a criminal and dismiss him overnight and tell him to leave. Okay, Umi, is that there's a question that you were supposed to copy paste for me. I've not seen.
Typing it, hold on.
Okay, let me see there's a question here. So for a person who is transferred to a different location with different superior, but same job description and general KPIs are also the same, can the previous PIP target goals remain and the PIP continues from before he was transferred? Yeah, so here what I understand is the employee does, let's say he's a HR executive. He carries on being a HR executive, but he's transferred from KL to JB, right? That is fine. There is no issue there. You can carry on the PIP with the same targets, but I would advise you to at least take into account that there has been a shift in environment. So because there's been a shift in environment, factor that in, and instead maybe the PIP was 3 months, maybe extend it to 4 months, right? Giving him some time to adjust to the new work environment. some sort of leeway and document it that, hey, your PIP was supposed to run from January to March. We are, however, extending it to April. And the reason why we are doing it is because we have taken into account that you have moved to a new place, a new location. And this would give you a fair opportunity to improve your performance. That's about it. Okay, let me take the next one. After the PIP 6 months, staff has improved on work performance. Unfortunately, a year later, the work performance started to decline. In this situation, the company dismissed the staff on this ground, or should the company repeat? I would advise you to repeat the PIP again. Because what will happen is the court will look at it and say that this guy was put on PIP. His performance improved. Why didn't you do it again? Right? Why didn't you give it another try? It showed that it was successful previously. Maybe it would have been again, right? There was no reason for you to jump the gun and again just dismiss the employee. So I'll advise you that in such a case, fair opportunity may mean giving him another shot. Okay, just I see a question here. Is it possible to initiate a PIP when the performance is mainly due to attitude or mentality? Example, slacking, less proactive, no sense of urgency. Yes, you can. Actually, your answer is just that. So not proactive or no sense of urgency. So it's timelines. So that's where you initiate a PIP and you tell them the part of the PIP is every Monday every day for 10 minutes or 15 minutes, I will have a chat with you. You will tell me what you're doing today and I will tell you the time of when I need it. Or every Monday, I will sit down with you, have a call. You will tell me these are the reports you're preparing. We will then discuss timelines and you need to keep to these timelines. And then the employee doesn't keep to these timelines because that's exactly what will happen. The call will ask you, did you take some steps to, sit down with this employee and tell this employee that you're not doing work fast enough. I need you to be faster. I need you to give me this by this date, this by that time. And do it over a period of 3 months. And once that 3 months is done, you will then be able to assess whether after you hand-holding this employee, guiding this employee, counseling this employee, whether he still performed or didn't. And if he didn't perform, then you cannot carry on employing this employee anymore. You will have to. You can dismiss the employee.
Okay, that's our last question, Mr. Amardeep. Thank you so much for joining us today. See you again in the next webinar on the 27th October.
Oh yeah, thanks. Thank you, everyone.
Thank you very much, Mr. Amardeep Singh. We hope to see all of you again in our upcoming webinars. Thank you, and Godspeed from IR Law. Thank you.
See you all.
Okay, thank you. Bye.
Thank you. Thank you.